Hello, I'm Dr. Leonard Berlin, Professor of Radiology at Rush University and the University of Illinois in Chicago. Today I'm going to speak on lessons learned from a mock trial that we had at the RSNA annual meeting. RSNA is the Radiological Society of North America, the largest of the radiology organizations. The meeting was held in Chicago very past November. And it was a mock trial. In other words, not a real trial, obviously. It was a trial, a version of a trial, a summary of a trial that was held over 3 or 4 hours rather than a week or two that a real trial would be held. It concerned a woman who at the age of 22, hypothetical patient obviously, who at the age of 22 made a total of 6 visits to a hospital emergency department with chest pain, suggesting pulmonary embolism or PE. On 5 of those visits, the ED physician ordered a CT angiography to rule out PE. On one of the 6 occasions, ordered a CT coronary angiogram to rule out coronary artery disease. This was all done within a period of less than 2 years, 18 to 24 months. Well, the woman later married. She had 2 children. And then, about 11 years later, at the age of 33, she was diagnosed with breast cancer. Notwithstanding treatment, she died 2 years later in 2011. Prior to her death, learning that exposure to diagnostic radiation could lead to cancer by reading the newspapers, listening to the news media, she and her husband consulted an attorney. And they wound up filing a malpractice lawsuit against the radiologist who had interpreted the CT scans. What they charged was that the radiologist was negligent for failing to alert either them or their doctor of the possible relationship between radiation and cancer, and that after 6 of these CT scans over a short 18 to 20 month period, that certainly somewhere along the line, the radiologist should have spoken up and said, do you really need all of these negative, by the way, they were all negative, scans? Anyway, because of the CTs, because it was done back in 1999 and 2000 era, no exact records of radiation exposure were available today, but in looking at the records that are available, the cumulative dose has been estimated to be somewhere between 200 and 250 millisieverts. Well, the radiologist, of course, denied negligence. The family pursued it, and there was no settlement, and the case proceeded to trial, and the trial begins. And the trial began this past meeting at the RSNA meeting. We had various participants real quickly. This was held in Chicago. We had a real sitting judge. Her name is Judge Claire McWilliams. She is a current judge who does a lot of malpractice cases in the courts in Chicago. The plaintiff's attorney is Keith Haybison from the firm of Clifford Law Offices in Chicago. The defense attorney, Timothy Nichols from Swanson Martin Bell, also in Chicago. Very prominent law firms on both sides of the table. We had expert witnesses for the plaintiff. We had Rebecca Smith-Bindman, professor of radiology at UCSF, UCSF. Stephen Balter, a PhD, clinical professor of radiology and physics at Columbia University in New York. Now on the defense side, we had Michael Branczewski, MD, clinical professor of radiology at Stanford University, and Cynthia McCullough, PhD, professor of medical physics at the Mayo Clinic. Acting as the defendant radiologist was Jonathan Berlin, who was associate professor of radiology at the University of Chicago. Now, so we proceeded as a trial would proceed, obviously very quickly, but nevertheless. So let me just quote a couple of the high spots of the opening comments made by plaintiff's attorney Haybison, who was the first person to address the jury. And by the way, we had 12 jurors, lay people who were selected by the RSNA after getting a bunch of volunteers. These people on the jury had no relationship to radiology or radiologists, and they were there not knowing exactly what the trial was going to be until just before we told them it was a case of possible cancer from radiation. Okay, so this was the opening statement, the highlights of the opening statements without going into about 20 minutes worth. I'll keep it down to about a minute or two. Attorney Haybison addressed the jury. He says, because of the inappropriate assessment of benefit and risk CT studies that were done when she was younger for repeated symptoms of PE, this young lady developed breast cancer. She has 6 CTs in all within a period of less than 20 months, all interpreted by the same radiologist as normal. The evidence will show that the radiologist, instead of using medical judgment to assess whether each CT was necessary, remained silent and allowed them to be done when there was no justification for doing so. He went on to say, we know the CT uses radiation, which can harm people, and evidence will show that the cumulative dose was sufficient to cause the patient's breast cancer. Furthermore, radiologists have a duty, beyond merely rendering interpretations, to know the risks of the scan, and thus, by the third or fourth CT scan that this woman had, he should have spoken up and discussed, perhaps with the ED physician, or if not, or the patient, suggesting that there might be this connection and that any benefits you would derive just might be overshadowed by the unjustified risk of the radiation. Okay, that was basically the short summary of a 15-minute opening statement. Now let's look at the opening statement by defense attorney Nichols. Again, very short summary of a 15 or 20-minute opening statement. Nevertheless, what Attorney Nichols highlighted was as follows. He says, the radiologist was called to interpret the CTs, which he did so correctly and appropriately within the standard of care. The standard of care in 1999-2000 did not require radiologists to discuss hypothetical risks of low-level radiation with the patient and the doctor. Even today, in 2012, this was 2012, radiologists and physicists disagree about whether those risks are realistic, and the debate continues. The patient had symptoms of pulmonary embolism, which at present could have caused her death. The ED physician and the radiologist both performed their duties within the standard of care. Now you will hear about the hypothetical risk of cancer based on patients who receive large doses of radiation, which have been extrapolated down to low levels. But you will hear that low levels do not cause cancer. There may be debate about the need for discussion today with patients and doctors, but remember in 2012, there was no such debate as being the standard of care in the 1999-2000 time frame. All right, so Attorney Hay-Bison called his first plaintiff's expert. The plaintiff's expert was Stephen Balter, PhD, as I say, physicist, professor of radiation and physicist at Columbia, New York. And basically, in short, again, to condense 10 or 15 minutes of testimony, Dr. Balter said the radiologist is a consultant to the referring physician. The referring physician makes a request, but the request is not an order. So he opines that radiologists must exercise medical judgment as to whether each request is reasonable. The risks of radiation from CT are not hypothetical, they are real. It is more likely than not that the radiation in this young woman at the age of 22 did indeed cause the breast cancer. And he went on later showing slides, which I will not show today, substantiating his opinion. But he went on that even in 1999, the radiologist should have known this. The cumulative dose increases risk. And what he said was kind of interesting. He said, if you are buying more lottery tickets, the chances of winning are increased by the more you buy. In other words, the more you have repeated CTs, the more likely, or the more higher the risk, and the more likely that you might develop cancer. Okay. So Attorney Hay-Bison then next called the second plaintiff's expert for him, Rebecca Smith-Bindman, professor of radiology at UCSF. And again, to condense 15 minutes of testimony, basically the highlights, Dr. Smith-Bindman said, radiologists are consultants to clinicians who order tests, and we, the radiologists, know more about these tests than they do. When imaging tests are associated with the radiation, because of our expertise, we must communicate with the referring physician to make sure they are doing what is best for the patient. There is compelling evidence from thousands of studies, including the Hiroshima survivors and environmental accidents, that radiation from CT can cause cancer. She goes on to say the risks from this radiation are not hypothetical. A dose over 200 millisieverts we know is harmful, and cumulative doses are even more so. After the second CT that this woman had, the radiologist should have contacted the physician and asked whether the study was really necessary. The radiologist was negligent for not talking to the referring physician and or the patient about the real risk of the time by the time the 5th and 6th CTs. He should have really talked by the 2nd or 3rd, but certainly by the 5th or 6th CTs. Well, after the plaintiff's attorney finished with his expert witnesses, then the defense attorney, Nichols, called his first expert witness, which was Dr. Michael Brantzewski from Stanford University in Southern California. And what he said, again, to summarize the 15 minutes of testimony, I know of no radiology department in the U.S. in the 2000 frame, where patients or physicians were advised of risk of the radiation. And in fact, I don't know of any today as well. Radiation in high doses can produce cancer, yes, but there is no evidence that it does at low doses. And certainly, there is no evidence that 2 or even 5 CTs or 6 CTs will cause cancer. I don't know how a radiologist can give truly informed consent given the controversy and debate on the topic about potential harm from low-level radiation. And he continued, relative to cumulative doses, each time the scan was done, the body could repair any DNA injury that was caused by the radiation by that tiny dose. And he pointed out, it is not like chopping down a tree where each slice of the axe sensitizes the tree to fall with the next slice. If the axe chops are spaced over time, the bark may grow back, and thus the next slice does not add to the first one. He is obviously equating that, using that as a metaphor for radiation, that these were not 6 CTs done all on the same day or within the same week. They were spread out over 18 to 20 to 24 months, and it was an interesting metaphor, to say the least. Now, the next defense expert was Cynthia McCullough, professor of radiology and physics at the Mayo Clinic. Dr. McCullough went on to say, the evidence is not sufficient to conclude that the CT exams obtained on this patient resulted in breast cancer. Whether moderately low levels of radiation can cause cancer remain controversial. Radiation as a carcinogen has been the most studied carcinogen for decades, and the debate still remains. There is absolute danger of levels, but we cannot extrapolate those high levels that were received in Hiroshima or Nagasaki or in major industrial nuclear reactor accidents down to low levels, because the body does have an incredible repair mechanism. Dr. McCullough goes on to say, much data come from the atomic bomb survivors, but with them, the radiation dose was enormous and instantaneous, and in addition, the people were malnourished and did not have adequate medical care. Today's population is well nourished and has good medical care. Repeated small doses of radiation is like a vaccination. We add a little bit of challenge to our immune system with the flu vaccine, for example, and our body builds immunity and becomes stronger. As for repeated CTs for possible pulmonary embolism, the physician has to consider each visit individually. The study may be negative the 1st, the 4th, the 5th time, but just because it's negative for 4 or 5 times doesn't mean that by the time you get to the 6th time or so, or 5th, that it may be positive. Nobody wants to miss a pulmonary embolism. Well, also called, of course, quickly was the defendant radiologist. And the defendant radiologist said, of course, he testified that he did not mention anything to the referring physician nor to the patient about the repeated CT scans. He felt it was not necessary. He felt there was no reason for him to, that these were ordered by the physician, and that obviously it was to rule out pulmonary embolism or coronary artery disease, and were well founded. It was not for him to question. There was a brief testimony from the surviving husband of the woman, who said it is true he accompanied her on all of the ED visits, and it is true he was just asked a simple question, did the radiologist or anyone discuss with you or your wife about the connection between radiation and CT? And of course he said no. All right, so now we come to the closing arguments, all right? The closing arguments, plaintiff's attorney Hebais, facing the jury. The patient had 6 normal CTs. This is a case of inappropriate assessment of benefit versus risk, which should have been raised by the 3rd or the 4th CT by the radiologist. The radiologist had an obligation to at least raise his hand and say, these repeatedly negative CTs that generate radiation risk make no sense. Bring it to the attention of the referring the ED doctor. You have heard that cumulative doses do increase the risk of CT, and the patient dose here was sufficiently high to more than likely not cause her breast cancer. More than likely than not cause her breast cancer. This is a case of unnecessary tests without the radiation, without the radiologist raising his hand about it. He, the radiologist, is the one who knew most about the risk, and he failed in his duty. The radiologist, that was the end of the plaintiff's argument. Closing statement, defense attorney Nichols then spoke to the jury and gave his closing argument. The radiologist accurately interpreted and communicated the results of the CT scans and thus complied with the standard of care. There is no evidence that would demonstrate in 2000 or even today in 2012 that it was more likely than not that these 6 CT scans caused the patient's breast cancer. There is ongoing debate, which is good, but to accuse radiologists of negligence defies common sense. We know that pulmonary embolism can lead to sudden death if not diagnosed. It was the physician, the ED physician, and not the radiologist, keep in mind, who ordered the CTs. Well, the jury was then instructed by the judge, and they went for deliberations. We had a video and an audio feed of the jury deliberation. And it's kind of interesting. Let me go over a few of the quotations of some of the jurors, okay, nameless jurors. And these are all quotation marks. And these are different jurors speaking up to the deliberation. If the patient comes to an ED with symptoms of PE, what does it matter if it's 1 time or 10 times? Each time the emergency room physician has to decide if a CT is needed. Just because several in the past were negative, but there turns out to be a PE now and there was no CT or diagnosis, golly, and the patient dies, what do you have? You get sued. Okay? Here's another one. It does not matter to me whether it was 1 time, 5 times, or 10 times. If you present with the same symptoms, you have to be diagnosed and treated accordingly. Should the patient question and want to know why she is getting repeat studies and if they would cause any harm? A radiologist does have the burden imposed on him. He has the education to determine if the tests are necessary, and he knows the risks of the CT. The radiologist has a duty to discuss it, and maybe he should be blamed. Maybe he should be blamed if the patient gets too much radiation. Isn't the radiologist a consultant? It is the ED physician who ordered the scan, and when the doctor orders it, the patient should get it. Okay? No, there are different comments. You don't want somebody to die if they did not get CT because of the worry that she had too much radiation, because this is the 5th or the 10th time that she's getting the CT. This case is based on the fact that the radiologist did know she was in for her 6th CT, and therefore he has the responsibility to go back to the ED and say, hey, this is her 6th scan, I'm worried about radiation, let's talk to her and about the possible effects of being exposed again. But clearly in 1999, this was not the standard that was expected. Maybe now in 2012, but no one then knew that radiation could cause cancer. It was the negligence on the radiologist's part not to discuss possibilities with the patient on a 3rd through 6th test. If it was my family, I would like to have made the decision as to whether to expose my family member or myself to another CT right after the other. Whether someone might die or not in my family, either way, I want to be able to be part of that decision. Every time I go to the doctor with severe chest pain, it's a matter of life and death. I want to be diagnosed correctly for a heart attack or pulmonary embolism. I put myself in the doctor's hands, thinking he knows what is best for me. And I say, if I need this test, I don't question it. What bothers me is the cumulative effect of CT scans, 6 CTs. This bothers me more than anything, the cumulative effect of radiation. But there are a lot of things we believe that are not scientifically proven. Well, those are the interesting quotations from the jurors. Now we come to the jury verdict. Of course, they return to the courtroom. The jury verdict is interesting. 7 found in favor of the defendant and against the plaintiff. five found in favor of the plaintiff and against the defendant, and when they did so, they assessed damages of $1 million. Well, what are the lessons learned? Well, let's talk about this for a minute. Let me, first of all, emphasize that this was a fictional case. Our goal was to have a spirited, intellectual, educational debate about the issue of radiation exposure derived from CT exams and other imaging studies and the potential development of cancer. The split decision of the jury was really interesting. This can be seen by the excerpts and the comments made by the jurors. They did listen to the testimony, and they did give it very serious consideration. Now, there was no unanimity among the jurors, but that's not surprising considering that there's no unanimity among radiologists, radiation physicists, and other scientists who for many, many years have been studying these issues. So what are, the lessons learned? Well, let's again refer back to true informed consent. The issue here is really not the need to give true informed consent, but rather whether the radiologist then, 2000, or now in 2012, or actually 2013 today, if the radiologist becomes aware of overutilization of CTs in a particular situation, if that radiologist has a moral or legal duty to at least bring to the attention of the referring physician the potential risks, and in some cases, to the patients themselves. That is the question. Now, historically and traditionally, obviously it is the physician who orders the exam and the radiologist who interprets it. Is the radiologist simply a bystander, or does the radiologist have a duty to evaluate the request for the exam and intercede if he feels the exam is unnecessary and the patient is exposed to needless radiation? I put a question mark on that. Radiologists are encouraged by our own societies now to be consultants, not simply bystanders or technicians. Some radiologists now feel they should review requests for exams in the interest of reducing costs and minimizing radiation exposure, and intervene if the exam seems unnecessary. Although such action is not, and let me emphasize, is not the standard of care today. Certainly, in most cases, the judgment of the ordering physician need not be questioned. But if the radiologist notes that the patient has had multiple similar CTs or similar exams in the recent past, perhaps, and I say perhaps, the radiologist has a duty to contact the referring physician, suggesting an alternative non-radiation exam be considered or cancel a request. The debate continues. No finite answers are available today. The lawsuit discussed, remember, the lawsuit discussed here right now was a mock trial. It was hypothetical. I know of no current medical malpractice case that has been filed in recent years or currently that are alleging that cancer has developed from diagnostic level radiation. But will in the near future a lawsuit such as this be filed? It may well be. So with that I conclude, and I thank you very much for your attention.